Welcome everyone, this is Amer from U Counsel. Today we'll talk about how do lawyers charge their fees in Canada. Before we begin, there's the usual disclaimer that this course is not legal advice, and if you have any specific questions, you must contact your own lawyer or paralegal or the Law Society of Upper Canada for any referrals. Legal fees usually have two components. One is the legal fees itself, which is paid to the lawyer, and the second component is disbursements. Disbursements are all of the costs associated with your legal case. So let's talk about disbursements first. Some of the things that we can give you an example of disbursements are court fees. For instance, if you commence a court action in the court, you will have to provide certain fee for the commencement of that court action. Similarly, there are other instances within the court action where you may have to provide some fees along with it. So for instance, if you are bringing a motion, there are fees for motion. If you are setting your matter down for trial, then there are fees for trial. So court fees are part of disbursements that clients are responsible for. Similarly, process server fees. Process server is sort of a glorified term for a high-end courier, if we may call it that. If you have watched any movies where you see that somebody is at a restaurant or at a club and one person taps on their shoulder and the person turns around and says, "John Smith," and the answer is yes, and then they hand over certain papers and say, "You have been served." So that person who is doing that role of serving documents is called process server. And process servers do a variety of things for law firms and their clients. File documents with the court, serve it on different parties, get records from the court, and so on and so forth. So they charge their fees, which are part of a client's disbursements. Similarly, there are fees like agency fees. For example, if you go to mediation and you have to hire a mediator, the cost of that will come under agency fee. In medical malpractice cases, you may be getting your medical reports from doctors and other sort of clinics, and those may fall under agency fees as well. So anything that, any fees that you pay to some third party, sometimes you hire actuaries or damage consultants to provide expert evidence to the court, and so there may be fees associated with that. So all of those are sort of come under the umbrella of agency fees. And smaller kinds of fees are copying and binding and faxing and long distance calls and whatnot. So key thing to note here is that disbursements are costs that are associated with your particular case, depending upon what it is, and those costs are the responsibility of the client. Mostly law firms obtain a retainer from the client and they use that money to pay for the disbursements as they go along, or they can ask the client to pay directly to the vendor for those disbursements. Coming to legal fees, there are generally, the fee structure is generally of three kinds. One is hourly fee structure, second is flat or block fee or fixed fee structure, and third is contingency fee structure. So we'll cover each one by one. Hourly fee, as the name implies, is based upon the number of hours that the lawyer works on your case and then charges it accordingly. So for instance, if a lawyer charges $400 an hour, then and works on your file for 2 hours, then the legal fees are $800 plus tax. Hourly fees are captured usually in 1/10 of an hour. So if you see a notation of 0.1 as the time entry for the lawyer, that indicates that the lawyer has worked on that specific task for 6 minutes or less. In hourly retainers, you will see quite detailed invoice statements from the lawyer indicating the date and the time that the lawyer worked on your specific matter. So what date that the lawyer worked on your file and what specific task did he or she perform in that file, and then how long did it take him to do that. So those are recorded as the lawyers do their work. They have their software. In most law firms have software where they keep on recording, and then once the invoice is generated, all of that information is already there. Hourly fees are not dependent upon results. If the lawyer has worked X amount of hours whether you win the case or you lose the case, you're liable to pay those fees. Second model is the flat fee block fee model, which is sort of now becoming more popular, primarily because clients would like certainty in terms of what cost they will incur for a specific matter. So these, as the name implies, are fixed fees, and mostly they are coded per specific task. So for instance, in employment law practice, if we are drafting a statement of claim or a statement of defense on behalf of a client, we will, and if the client is interested in obtaining a block fee quote, then we will advise the client based upon the amount of work that we'll have to do that this specific task will cost X amount of dollars. And those tasks are then listed in the retainer agreement along with the fees that will be charged. And the retainer agreement also covers some of the unanticipated costs that may arise. For instance, if the other party brings a motion of some sort which was not part of the usual court process, then the lawyer may advise that if that happens, then X amount of dollars will be charged for that particular task. So the main function of block fees or flat fees is that they provide certainty both to the client and to the lawyer in terms of the cost of that specific work that is being done. Again, like hourly fees, these are not contingent upon results. As long as the lawyer has performed the work, the success of that matter is not relevant in the case, and the lawyer is entitled to the fees that are agreed upon. Third model is the contingency model, and as the name implies, it is contingent upon the results. So most contingency retainers indicate that lawyer will only get fee if the client is successful either in a settlement or in a judgment. And if there is no, if the client is not successful, then there are no fees towards the lawyer. So in contingency fee models, a lawyer takes significant risk on the file. So obviously his or her analysis of the case is that strong that he or she is willing to put his or her own time and effort in hopes that there will be some fees generated because of the results that the lawyer will achieve. So contingency fee model is based upon usually on the percentage of success. So it could range anywhere from 25% to 35% or so. And once the settlement is achieved or the judgment is awarded, that percentage is paid as legal fees. Important thing to keep in mind in contingency fee retainers is that if your matter goes to trial, all the way to trial, and you're unsuccessful, you lose the case, the court will award some legal fees against you to be paid to the other side. And if that's the case, then you, the client, is responsible for payment of those fees. The lawyer is not responsible for paying fees to the other side. So the only risk that the lawyer is taking is upon his or her own legal fees, but not on the other side's legal fees. So if you lose, then you have the burden to pay the legal fees off the other side. And finally, keep in mind that all of the disbursements that are incurred even on a contingency file are also a client's responsibility, because these are costs associated. These are not monies that are to be paid to the lawyer, but are paid to the vendors and third parties. Those are always client's responsibility, whether they pay at the outset or whether they pay towards the end, depending upon which law firm and what kind of case you have. So that's the contingency fee model. So those are sort of the three major models that are in place. I want to go back to sort of the block fee model one more time. This has become popularized, as I indicated. One of the primary reasons why it's so popular now, and increasingly so, and probably still underutilized, is because law societies across Canada have generally now created this option of hiring lawyers on a specific task basis. It's called unbundled services or limited scope retainer, and I have talked about it in a separate lecture on self-representation. You can find more information on that. But essentially the idea is that because the legal fees are the cost of retaining a lawyer have become so exorbitant, and it's so hard to retain a lawyer on a long-term basis on the length of the entire file, you can actually choose when you want to bring in lawyer to do a specific task and then just pay them accordingly. So because there is now the option of unbundled services and specific or limited scope retainer, you can actually negotiate flat or block fees for that specific task, and then have the lawyer represent you only for that part of your case, and then you can continue to perform your the representation of your case on your own. Or you can have the lawyer represent you for the entire length and still negotiate the flat fee, but this does give you certain certainty. Okay, so let's go back to now sort of the last slide that I want to talk about, which is fee and the selection of lawyers. So there are two things that obviously the lawyer want from the clients want from a lawyer. They want the certainty of the legal fees. They want to know exactly how much money they will incur in with respect to a matter, and they want some certainty or guarantee in terms of the results they will achieve. So I want to talk briefly about both things. Certainty in legal fees, it's something that obviously people want. They want to know how much money they're going to spend to, if you're buying a pair of pants, you want to know exactly how much you're paying. You don't want to be in a situation where the manufacturer says, well, it depends upon how often do you wear the pants, and how do you use them and whatnot, and our fee or our cost for the pants will be based upon that. So it's an odd way to pose that, but just because the legal structure is so different, the certainty is possible in some cases, in some cases not. I mean, you get absolute certainty when you have block fees, and you know how much you're incurring. But even in block fees, there are unanticipated steps that may happen, not because of you, but because of the other sides, especially in court actions. And so even though you know the certainty of, you know exactly how much you will pay for that unanticipated action, that may still increase the overall cost of your spending, overall cost of your legal action. So certainty is achievable. It's more and more possible. In my practice, I'm pretty confident about every single step and how much it costs my client, and I can provide that certainty, but sometimes it's not possible. So and the second component is results, and you be wary of any lawyer who guarantees any success of any kind, because the simple fact is, when you have a court action, it is a judge or a panel of judges who are going to decide, and they may decide against you no matter how strong your case is. So there's no guarantee. A lawyer can always indicate to you that based upon previous cases and based upon jurisprudence, your chances of success is very high. It could be 99%, it could be 99.9%, but it can never be 100% guarantee, because the lawyer himself or herself is not the decision maker. It's somebody else. And depending upon how your case performs, and you may have a bad day at court and your testimony may not be as strong as your case is, and so that may jeopardize the success of your case. So there's no guarantee of results. Yes, the lawyer can advise what are the chances of success, and your chances of success could be very high. So those are sort of the two cautions. And with that in mind, we want to talk about whether you want to hire a lawyer whose legal fees or hourly rates or contingency fees are lower versus a lawyer who charges a lot more, and what role should that play in your decision to hire a lawyer. So obviously, I completely agree with you that the cost of legal services is a strong component for a client to decide which lawyer to hire. But I want to give you the word of caution that hiring a lawyer is no different than hiring a plumber or hiring a general contractor. And you would not simply hire a plumber or a contractor because the rates that person is offering are the cheapest. And so the same principle should apply in hiring a lawyer. And so my recommendation is that fees should not be the sole factor for you to decide whether to hire the lawyer or not. It should be one of the factors, and you should obviously get referrals, get some understanding of whether the lawyer has expertise in what you want, whether the lawyer will be suitable for your kind of case, and obviously whether the costs are within your reach. So it should be one of the factors, but not the sole factor. Hopefully this lecture has given you some insight on how the lawyers are retained and how they charge their legal fees in Canada. Look forward to any comments, anything else that you want to explore in this area further. Please send us a comment, send us a note, and we'll be happy to include that in our next lecture. Thank you for watching.